Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled One Way to Lose Maritime Lien. A maritime lien is created when certain goods and or services are provided to a vessel. See Pacific Maritime Magazine, Maritime Liens 101, November 2010. It is a non-possessory lien, meaning the lien holder has a claim against the vessel but does not have physical possessions of the vessel. However, the lien holder can lose the maritime lien under certain circumstances. This column discusses one way in which a maritime lien can be lost. Maritime lien basics. Federal maritime law gives a maritime lien to a party providing certain necessaries to a vessel. Under federal statutory law, necessaries include repairs, supplies, towage, and the use of a dry dock or marine railway. Maritime liens can also be created when dockage and agency services are provided to a vessel. Unlike liens against real property, a maritime lien against a vessel does not have to be recorded to be enforceable. Maritime liens can be enforced in only one way. A complaint must be filed in federal court naming the vessel against which the lien is asserted as a defendant. Then the defendant vessel must be arrested by the United States Marshal. If the vessel owner does not pose security to obtain release of the arrested vessel, the vessel may be sold at a public sale conducted by the marshal. When a vessel is sold at a marshal sale, all liens against it not satisfied from the sale proceeds are extinguished. In addition to a marshal sale, there are other ways in which a lien can be lost. One way is by waiver. Lien waived. A waiver is the international relinquishment of a right or claim. Under certain circumstances, a court will find a maritime lien has been waived by the lien holder's words or conduct. Puerto Rico Ports Authority v. Berge KTB 427 F3rd 93 2005 illustrates the point. In that case, the barge KTB was moored at a pier operated by the Puerto Rico Port Authority or PRPA. For almost 4 years, the barge owner had a lease with the PRPA which required the barge owner to pay daily dockage fees. The barge owner refused to pay, citing the failure of the PRPA to provide adequate terminal facilities. In June 2003, the PRPA began eviction proceedings against the barge owner in a local court, but did not include a claim for the owner filed a counterclaim against the PRPA alleging damages for breach of the lease. In early 2005, the PRPA told the barge owner that it wanted the barge removed from the pier before the start of the hurricane season. The barge owner wanted to comply with the PRPA request by selling the barge. However, the PRPA had a maritime lien against the barge for more than $1.7 million in unpaid dockage fees, which greatly exceeded the barge's $500,000 value. The substantial lien discouraged potential buyers. Representative of the barge owner and the PRPA met to discuss the PRPA intention regarding enforcement of the lien for the unpaid dockage fees. The barge owner council requested the PRPA to waive its lien in writing and to seek collections of the unpaid dockage fees from the barge owner in the evictions action pending in the local court. The barge owner understood that a letter from the PRPA to the effect would help the sale of the barge to a third party. As a result of the meeting, the PRPA wrote a letter to the barge owner stating it had no objection to the sale of the barge or its departure from the pier. The letter also acknowledged that the dockage fees were being converted in the pending eviction action. The barge was sold on June 3, 2004 to a third party. The next day, the PRPA recorded a maritime liens against the barge. Later in June 2004, the PRPA began proceeding to enforce its maritime lien and arrange for the arrest of the barge. The new buyer intervened in the action. The district court held the letter written by PRPA representative was knowingly intended to influence parties who might be considering buying the barge and constitute a waiver of the maritime lien for the unpaid dockage fees. The First Circuit affirmed the district court, holding that the maritime lien for unpaid dockage fees had been waived. It recognized a lien holder's right to waive a maritime lien for necessaries, which waiver needed not to be expressed. However, it noted the party trying to establish a waiver of a maritime lien for necessaries has a heavy burden of proof. It must show the lien holder took an action demonstrating a look solely to the vessel owner for payment. The First Circuit reasoned the letter was hardly a model of precise draftsmanship. It did not expressly waive the lien or even mention the lien. Nonetheless, the court found the letter could be read as consistent with the waiver of the lien. The letter acknowledged the parties were litigating over the dispute dockage fees in the local court and stated there was no objection for the sale and removal of the vessel from the pier. The representative of the PRPA testified he knew the representation in the letter would be relied on by prospective buyers who would understand the dispute or charge would be addressed in the pending eviction action. The First Circuit also agreed with the district court, stating the PRPA laid in wait knowing buyers who treat the letter as a waiver of the lien and then pounds once a purchaser took the paid in sum. Although the letter did not expressly waive the lien for dockage, the record taken as a whole led to the conclusions that the PRPA took deliberate and purposeful step to make clear intent to forego its lien for dockage fees and rely on the pending local court action against the barge owner for payment. Accordingly, the court held the lien was waived. Lien not waived. SAE, Maduro, Florida, and MV Antonio de Castaneda involve a lien asserted by a sub-agent of a vessel, General Agent. Maduro was hired a port agent by the vessel owners, General Agent, to provide service and supply the MV Antonio de Castaneda. It provided service and supplies upon the request of a vessel charterer. So that's all the article. Bye bye and Don't forget to like, comment, and subscribe. Bye.